Good afternoon. My name is Ramesh Maharaj. Yesterday afternoon, Justice Robin Mohammed gave a written judgment in a matter which is of great public importance. That judgment, which was handed down, consisted of 129 pages, and the judge declared that the failure of the Minister of Health and the Cabinet of Trinidad and Tobago to do what was necessary to facilitate the operation of two full-service renal dialysis centers at the Eric Williams Medical Sciences Complex and at the San Fernando General Hospital was unlawful in public law and also in constitutional law. The right to life of members of the Caribbean Kidney Disease Society was violated by the failure and delay of government in making these two centers operational. The judge directed the minister and the cabinet within 42 days to favorably consider his judgment and to make a decision in relation to the construction and operation of the renal dialysis centers, which have been on hold for about 12 years. In giving judgment in favor of Comprehensive Nephrology Services Limited and Biomedical Technologies Limited, which together had commenced construction of the renal dialysis centers, the judge said that millions of dollars had been spent by them and that it was wholly unreasonable for these centers to be delayed because of cabinet and ministerial inaction. The judge also stated that the lives of kidney patients were imperiled as a result of the failure of the government to establish and operate these centers. He ordered the state to pay the costs of the claim. This was an important development in public and constitutional law to protect the right to life guaranteed in the Constitution of the Republic of Trinidad and Tobago. In that case, I appeared on behalf of the claimants, and I was assisted by Mr. Ronnie Bisesa and Mr. Varun Gopal Gosai. The Cabinet and the Minister of Health and the North Central Regional Health Authority were represented by Mr. Douglas Mendes, Senior Counsel, and Mr. Michael Quamana, together with Mr. Charles Lowe. Because of the importance of that judgment and the impact it has on the lives of the people of Trinidad and Tobago, and in particular, kidney patients and potential kidney patients, today I wrote an open letter to the Prime Minister making request for the implementation of cabinet policy for the construction and operation of those two centers in our country, based both on the High Court judgment and based also on a cabinet decision made in 2008. I addressed the Prime Minister by stating, among other things, Honourable Prime Minister, it is my respectful request that have regard to the right guaranteed in Section 4A of the Constitution of the right to life and the principles of public law for a government to honour legitimate expectations of substantive benefits created in favour of members of the public. The government has a duty to take immediate steps to implement the cabinet decision of 2008. The continuing failure of the government to implement that decision continues to put the lives of kidney patients at risk. This is supported by the judgment given in the High Court yesterday by Justice Robin Mohammed. There is a positive obligation on governments to take reasonable care to protect the lives of individuals, especially where it is recognized by the government that the lives of kidney patients would be at risk if adequate renal services were not provided to them. The Cabinet of Trinidad and Tobago recognized that this 13 years ago. It recognized in its decision that the public interest required it to establish and operate two full-service renal dialysis centers to offer clinical and non-clinical renal services to the general public, and the failure to do so would put at risk the lives of kidney patients in Trinidad and Tobago. The Cabinet decided that urgent action had to be taken to prevent this by having these two centers. There has been unreasonable delay for 13 years in government in not implementing this policy decided by Cabinet in 2008. The court found that there had been unreasonable delay in the non-implementation, delay in the implementation of this policy. Honourable Prime Minister, I draw this matter to your attention as head of the Cabinet so that you may consider taking steps for the Cabinet to urgently implement the decision of Cabinet made in 2008 and consequently also to implement the decision given by the High Court yesterday. I attached a copy of the judgment by showing that the judgment is available in a Dropbox link so that the Prime Minister and members of the media can access the judgment. The context in which this request is made, Honourable Prime Minister, includes the decision which the High Court gave yesterday. The court held that the failure of the Minister of Health and the Cabinet to do what was necessary to facilitate the construction and operation of these two centers was contrary to the principles of public law and that the inaction of the state violated the right of life of the members of the Caribbean Kidney Disease Society. Section 4A of the Constitution of Trinidad and Tobago guarantees to every individual in our country the right to life and the right not to be deprived thereof except by due process of law. The undisputed evidence before the court show that in 2008, the Cabinet decided that it was in the public interest to offer clinical and non-clinical renal services to the general public because there was an increasing number of kidney patients who required renal services. The Cabinet decided that the public healthcare institutions could not provide adequate medical attention for care for that illness to kidney patients. The Cabinet also decided that there were also shortcomings of the contracted private facilities in Trinidad and Tobago to provide medical care to kidney patients who required renal services. The Cabinet decided to proceed on a design, build, operate, and transfer model so that the contractor would bear all the costs of designing, constructing, outfitting, and operating the centers before transferring and handing back the centers to the government for the government to operate the centers. By adopting that model, there would have been no cost incurred by the government in the construction and initial operation of the centers. All financing and operating risks was to be borne solely by the contractor. Pursuant to that government policy, tenders were invited and a contract was awarded for the design, construction, financing, outfitting, operation, and transfer of the centers by the contractor with proven international experience. And those are the first two claimants I mentioned. The government policy was that the contractor, after designing and building the centers, would operate them for 13 and a half years before transferring the centers back to the government for the government to continue their operation. The relevant contract was executed by the government with the two claimants. The public statements made by the government on behalf of the government in respect of cabinet decision and its promised implementation created in favor of renal patients and potential renal patients an expectation that the government would in the near future, by implementation of this policy, provide adequate renal services for kidney patients and potential kidney patients. The government did not take steps to facilitate the expeditious execution of this policy of cabinet. The contractors in the meantime expended millions of dollars in the construction processes of these two centers, but the cabinet was guilty of unreasonable delay in vetting relevant documents to facilitate the implementation of cabinet policy. The judge made the following orders. The delay by the cabinet in failing to execute the relevant documents was unreasonable delay. The kidney patients who were members of CKDS had a legitimate expectation of a substantive benefit that the centers would be established and operated for them to receive renal services. That legitimate expectation of a substantive benefit in public law was unlawfully frustrated by the government. The continuing failure of the cabinet to take the necessary action to do what was necessary to facilitate the construction and operation of the two full-service centers was unlawful. The court also declared that the failure of the government to implement its policy to have the centers constructed and operated violated the right to life of the kidney patients who were members of the Caribbean Kidney Disease Society. An order that within 42 days for the cabinet to consider executing the relevant documents, taking into consideration what the judge found in respect of the rights and expectations of the claimants. And I told the Prime Minister that I was sending a copy of this open letter to the Honourable Minister of Health. So here it is, we have a situation in which the government does not have to spend a cent. Contractors spent millions and would spend further millions of dollars to construct these centers, to equip them, to operate them, to provide the expertise for 13 and a half years to operate them. Government would have no expenses during that period. After that period, the centers would be handed over to the government for the government to operate. And for 13 and since 2008, that is 13 years have passed, we have not been able to have those centers. If there was expedition in this matter, by now, the people of Trinidad and Tobago would have had these centers operated, and government would have had a continuing institution in order to provide renal services for kidney patients. This is an important and urgent matter. It affects lives, human lives, and the government owes a duty in order to implement this decision. I am sending this letter to the Prime Minister as head of the cabinet for the Honourable Prime Minister to take the necessary action in order to ensure that renal patients get the benefit of this institution. Thank you very much.